All right, hello everyone, and thank you for joining today's presentation and new webinar series brought to you by the SLW Institute, which was developed by the Schwegman firm to deliver educational and training content to advance your IP knowledge. My name is Brian Ness, and I'm facilitating this webinar series. Before I talk about the series in today's presentation, here are a few housekeeping items. If you have any questions during today's presentation, we encourage you to use either the Q&A or chat feature. Also, we'll be sending a follow-up email to each of you tomorrow that provides a link to the recording of this webinar and a copy of the PowerPoint. The IP Masterclass webinar series is a new series that is aimed to the patent practitioner that is looking to advance his or her legal knowledge and skill set. For today's presentation, Josh Garfield is going to present on proper citation practices and provide multiple examples of the most common mistakes made with citing documents and legal writing. Josh, I'll let you introduce yourself and take it from here.
All right, thank you, Brian. Good afternoon, everyone. My name is Josh Garfield. I'm a patent practitioner with Schwegman. I've been practicing for about 10 years. I primarily do patent prosecution, and some of my legal writings include responses to office actions, application drafting after final practice, post-grant proceedings, most of what's involved in patent prosecution. I've also had opinion drafting experience, providing opinions to clients, which of course includes citation work, and I'm also a member of some of the quality assurance teams we have at the firm, reviewing associate work product. And this is what prompted this particular class, is that I've noticed that there seems to be a bit of a disconnect between some of the quality of the substantive work product, but then the actual citations in the work product needs a bit of polish. And so part of this presentation, hopefully, you'll take away proper citation practice, some of the rules. Get a refresher on some of the rules in citing, how to properly cite documents from the patent office, your own work product. And this way, your legal writing is a bit more polished than what you maybe have done previously. So we'll just go through some of the topics of today's talk. We'll just go through some brief introductions, purpose of citations. We'll talk about the citation structure. When do you short cite? When do you not short cite? The various types of citations you can do, inline citations or in-text citations. Footnoting, because I know that there are practitioners who prefer footnotes over inline. ENDNOTES, we'll talk about when is that appropriate. Choosing the reporter to cite to. I know that there are some practitioners who prefer to cite to F3rd, some practitioners cite to the USPQ, some do both, some do neither, some only cite to Westlaw. Which of these, or Lexis, which of these reporters is the quote-unquote right reporter to cite? We'll also look at agency materials. That includes communications between you and the patent examiner. It includes decisions from the PTAB. It includes agency memoranda that might be published, and also includes decisions, notices that might be published in the Federal Register. We'll also talk about citing to patent literature in and of itself, including patents and published applications. What's the right formatting? What should it look like? We'll then take a look at what happens when we have multiple patent literature references with the same author. How do we treat those? How do we distinguish between the two references if they have the same last name? We'll then talk about citing to non-patent references. We'll talk about how and when to quote, inline quotations versus block quoting, how you distinguish between the two. When do you block quote? What does a block quote look like? What is the structure of a block quote? The citation signals. Sometimes you use IE, sometimes you use EG, C also. and then citing to slip opinions and when that is appropriate. So the purpose of a citation, there are a number of different elements that go into why do we cite. It provides authority. It identifies what the source, what source supports your proposition. It provides evidence so that someone can go back to that authority and see that yes, what the authority that you cited does in fact support the proposition that you're making. It also can provide additional background information. Perhaps the authority that you're citing has additional information that would be helpful in explaining your proposition or your argument, but it might be tangentially related to the arguments you are presenting. And then this way, by citing to this background information, perhaps you give the examiner or the administrative judge a bit more background information as to why your argument is the right argument. Citations also provide identification to parts of an authority that you're citing so that the reader can readily and quickly identify the material that is supporting your arguments. And of course, if you don't have the right format, if you don't have the right structure for that identification, the readers can be left searching for that support. And then also, ultimately, it also provides a set of uniformity that the reader knows what to expect when they encounter your citations. And all of this lends to better writing, because if your substantive arguments are on point, but your citations are, I don't want to say perfect, but less than polished or a little bit disjointed, that just detracts from the substantive points you're making. And in my experience, when I'm reviewing work, I look at those citations and I say to myself, this person, while their substantive arguments have merit and I agree with them, their citations are just not as strong as they could be. And so in my mind, it slightly diminishes the writing overall. And ultimately, when we write responses to office actions and appeal briefs and pre-appeal brief requests for reviews, ultimately these writings are not for ourselves, but we're writing to an audience that may later read them. We're building a record, and you want that record to be as strong as possible, so this way a litigator or other party, they can't attack your writing or call into question whether or not the citations you're providing in your document provide support for the propositions that you're making. So as we move through, I just want to hopefully highlight everything, bring back to life hopefully a book that you should have in your library. It's the Blue Book. Every practitioner, whether you're fresh out of law school or you've been doing this for 20 years, you should have a copy of the Blue Book in your library. It's now up to its 20th edition. I provided a hyperlink right to the source. You can get it. My copy was about 40 bucks. It's a dense read. I'm not asking you to read it all in one night, but you should at least become familiar with some of the pages in the Blue Book, including the blue pages, the white pages, and the rules that you're going to rely on most often. We're not going to go through the Blue Book in its entirety, but I am going to highlight some of the changes in the Blue Book that might be relevant to your practice. And then as we go through the presentation today, I will highlight some of what the Blue Book has to say. And I will note that the Blue Book doesn't cover every instance of proper citations. There are some practices that are just by convention, by what we've come to expect. So if you look at the Blue Book, there are about 27 new changes and revisions. The preface of the 20th edition does list these changes. You can read them for yourself. A lot of them simply aren't relevant. They have to do with non-patent literature references, the naming conventions, but for the most part, just aren't going to be germane to our talk today. There are some changes that I thought were interesting, which I'm going to highlight in the next couple of slides. And if you have your copy, if you have your 20th edition, you can look at these and see how these changes might impact your citation practice. There's some changes to Rule 10, clarifies the type of party names that should be found in a citation. Additional changes include guidance on the formation of slip opinion short forms, and we're going to be talking about this change later on and how you properly cite to slip opinions and when you should be citing to slip opinions. Rule 14 has been expanded to include comments from agencies, and we'll talk about how you properly cite to agency material, including both internal agency memoranda and communications from the examiner. So Rule 15 and 18 talk about citation formats for electronic resources. Unfortunately, I don't think today we're going to have time to talk about these rules on point, but if you find in your practice you are using a lot of electronic resources, and for a patent practitioner this might include resources from the IEEE, it might include sources from a website that the examiner might be citing to you. It might include journal articles that are, or white pages that are only available in PDF format. These are rules that you should review and look at and see how they apply to your situation, and hopefully you'll take away how these references should be cited. I know in my practice that most often these situations come up when the examiner finds a website that he or she might be using in a rejection order 102 and 103. Sometimes also comes into play when I'm drafting the application and I want to refer to a particular document to provide background information for 112 support. So again, you should become familiar with these rules. So we're going to now take a step back for a bit. We're going to go back to kind of a first-year law student refresher course on citations. We're going to build our foundation first. Yeah, in my view, you need a strong foundation before you can build upon it. So we're going to break down citation structure in general. We'll then move to short forms and how those appear, and I'll show you some of the common mistakes that I often see in my citation practice. In my practice in reviewing citations that I see by other associates in work product. So before, of course, so why do I bring this up a lot of times? Well, a lot of the times you'll get an office action from an examiner and they just go right to the last name of a particular reference. And that might be fine for an examiner. But as patent practitioners, I think we should hold ourselves to a bit of a higher standard. Our clients are certainly paying for it. So we should show that we have a good grasp on how we properly cite our authorities and how we cite our references and opinions. So a full citation form, what does this include? You're going to have 5 components. I've listed them here. You can have the name of the case, X v Y, Alice Corp v CLS Bank International, visual memory v NVIDIA. You're going to list out your case name, the published or unpublished source, and that's important because there are some instances where the case may be unreported or may not be yet available in any of the reporters. And then a parenthetical indicating the court in your decision, Fed Circ, Supreme Court, District Court. And this is especially important when you're citing to the USPQ, because the USPQ is not court particular. Of course, it's a collection of intellectual property cases. So we want to make sure you're citing to the right courts when you rely upon the USPQ. Other parenthetical information, this may include whether or not there is a rehearing denied, if it's en banc decision, if this certiorari to the Supreme Court. And you can read all this in the blue pages of the Blue Book, and then subsequent history of the case. And this was the subsequent history can be important in times when perhaps the Supreme Court overturned a case you might be relying on. This could be a situation where, for example, I recall years ago the Festo decisions were going up and down between the Federal Circuit and the Supreme Court, and that became important to cite to the subsequent history to show how that case was proceeding. So just to give you some examples of some proper citations, A shows you citing to the USPQ. You have the name of the case as it appears in the reporter. You have the citation, the volume and page number where it can be found in the reporter, and then the court. And here we have to identify the Supreme Court, US 2014, because the USPQ is a collection of courts. It comes from Federal Circuit, Supreme Court, some of the some early BPAI, some PTAB decisions, all make their way into the USPQ. Now, If we look at B, B is slightly different. This is what's called a parallel citation because you're also citing to the Supreme Court reporter. And here you're going to highlight that you're citing to both the USPQ and the Supreme Court. And if you notice, you drop the US designation because you cited to the Supreme Court reporter. The reader instinctively knows that you're citing to a Supreme Court decision, so you no longer need it. Moving on, how we see this in practice. So this is a recent office action I received, and this is kind of an example of what I want to show that I think we should hold ourselves a little bit of a higher standard than one expect from an examiner. This is the first time this case, Alice, is being introduced in the writing, and the author cites to the Supreme Court reporter. He gives a pinpoint cite at 2360, but this is the first time we're seeing it. And unfortunately, this is just not the proper way of introducing a court, an opinion or an authority at first instance. That should have been the full citation format. And I also see this, I didn't want to call it any particular work product today, but I also see this happening because instinctively, as patent practitioners, we don't have time. Our time is valuable. We don't want to take the few minutes it takes to look up the quick case name. So what do? We look at the office action response, and we simply repeat what the examiner has written to us. So now here, so my point is, don't just parrot back what the examiner has written to you in the rejection. Take it upon yourself. Reach out to whatever service you use, whether it's Westlaw, Lexis, BNA, Lois Law. There might be some Lois Law users. Reach out and find out what is the actual citation for this authority. And when you write back, when you write in your response, you're going to want to cite to that full citation when you first refer to it. Moving on. The next example here, we're going to cite again, just a paragraph here citing to Alice Corps. Again, here we cited to the USPQ, and in first instance, boy, this person knows what they're doing. They've pinpointed cited, they identified the USPQ, they've got the year of the citation, it's the first instance, so it's the full citation, but they omitted one crucial feature that signals what court issued this opinion. They left out the US, U period, S period, right before the year. And again, that's because the USPQ is a collection of cases, and you need to make sure you're citing to the right court, to the right decision. I didn't highlight it earlier, but if you look up early in the paragraph, you see a citation to Mayo. That citation is proper because you can see that they've had the full citation, volume, page, court, and year. So be careful, again, as you write, as you cite to the USPQ, if you decide not to parallel cite, that you're also including an identification of the court that issued that opinion. A difference between a citation and a reference. I'll take that real quick. A citation, you're identifying the reference. The reference is the actual work or is the actual document that the examiner might be citing to you. The citation is the formal identification of that reference. And it's important that your citations, again, conform at least to the Blue Book in some way, because you're going to provide uniformity and clarity to the reader as they go through your document. Now, after you've fully introduced your reference, can you then rely on the short form? Now, a lot of the times we see the short form right out of the gates when we get that rejection or we get that examiner's reply after we submit our appeal brief or in a final office action. Whatever it is, we get that short form right away from the examiner when they're citing to a case, and that's fine because, again, they're not paying, our clients aren't paying examiners. Their clients are paying us. We're expected to know better. So, a couple of rules of what I would call guiding principles to short form citation. First of all, the short form should be clear to the reader, the authority being referenced. For example, you don't want to use a short form where you have multiple cases with the same party names, and we'll get to that in a minute. The full citation falls in the same general discussion, and that means that if you have multiple authorities let's say your paragraph, whatever you're writing, involves Mayo and Alice and DDR and ENFISH, and so on and so forth, that when you're using that short form, it's going to be clear to the reader from among those many, many opinions that you're citing, which one the short form is referring to. And again, the reader will have a little trouble locating the full citation because, again, the reader, once you introduce that short form, the reader then has to go back up through the reading to find that full citation. And they'll have to do a little digging themselves. So let's make it easy on the reader. Let's make sure that we're using short forms that are readily identifiable. So when you're using the short form, some of the structure here is just use the name of the first party. You don't have to list Alice Corp v. CLS Bank. You don't have to do that. Alice Corp is sufficient. Again, when you're citing to Mayo, you just, Mayo is sufficient. We know what Mayo means. Same thing with DDR Holdings. I usually write DDR Holdings in its entirety because that's, again, that's the first party. You can drop the Inc. I believe DDR Holdings is DDR Holdings, comma, Inc. period. You can drop the comma, Inc. period. You can just cite the DDR Holdings. The point two here, unless the first party is a geographical unit, a governmental entity, or another type of common litigant, don't concern yourself with this exception. I've listed it here just so you are aware that there are exceptions. Like every rule, there are exceptions, and this just happens to be one of them. But you're rarely going to encounter this as you write your short form citations. You can shorten a longer name to a short name so long as the reference remains unambiguous. This is like in Mayo, we all say Mayo, right? We don't say the whole citation. We don't list it out the whole thing. We just say the first one, because once we say Mayo, the reader instinctively knows which case we're referring to. There's only one Mayo that concerns us, at least in our writing. So a couple of examples referring to Alice Corp v. CLS Bank. There's the full citation there. It gives a pinpoint cite, comma, 1978. It's what's called the pinpoint cite. It gives us the court, the U.S., 2014, the year of the decision. So a couple of proper short forms. You can write it as Alice at 1980. That's perfectly acceptable. Alice is readily identifiable. I know that you're at page 1980. You can then just cite also the volume and the reporter, 110 USPQ 2D at 1980. Very rarely do I see the just citation to the volume and reporter. More frequently than not, we're citing right to the name of the case. But if you do the 110 USPQ 2D short form citation, know that you are in good company. It is perfectly acceptable. And then, of course, our friendly id, and we're going to talk about id a little bit later. And here we see id at 1980. You'll notice a few things about id, and we'll get into it a bit later. You capitalize the I, you italicize the period, and then you follow the word id with the word at. Now, for some of you, you might look at Alice and id and say, hey, I italicize, or hey, I underline. Which one is more appropriate? They're both fine. They're both fine. So if you italicize, continue italicizing. If you underline, continue underlining. But you should only use one. Don't italicize and underline. Don't do both. No one does both. It's improper to do both. And if you're going to do id, if you're going to underline, it should be underlined. If you're going to italicize, it should be italicized. So once you've picked one style, whether it's italicizing or underlining, you're going to want to stick with it. So a couple of not proper citation formats: Alice Corp at 1980, listing the year, the court and the year. That's just not proper. We don't need to know that information. It's already in the long form citation. Here they have the next example I've seen is where you list both parties. Well, thank you for clarifying that, but we already know that the case is Alice Corp v. CLS Bank. We already know that, so you don't need to list both parties. And then finally, they list another common example. I don't see this too often in writing, but I wanted to highlight it here, that it's 110 USPQ 2D 1976 at 1980. You don't need the 1976. Again, I can get that information by referring back to the long form citation. So again, if you need a reference, a quick reference guide for how do I do a short form citation once I introduce my case, once I introduce my authority, you can go right to the slide and see some common examples of what to do and what not to do. Example 2, a case you'll probably see from an examiner, Accenture Global Services, GmbH. Now, unfortunately, here, the 108 USPQ2D and the Federal Circuit are italicized. They should not be italicized. So please disregard that. So look at some of the proper forms. Very similar to example 1. We list a censure, which is fine. You don't need the Global Services GmbH because it is clear. So long, let me rephrase this, so long as there's only one censure in your response or in your appeal brief or in your appeal brief request for review, so long as there's only one censure case that you're citing, it's perfectly acceptable just to use a censure. Then the next format is the volume and reporter with a pinpoint cite and then a friendly id brings up the rear. Not proper, Essential Global Services at 1176 Fed Circuit. Again, you don't need to identify the court in your short form. Naming the second party, Guidewire at 1176. So, sometimes you'll see the word Guidewire, or the examiner will cite to Guidewire in the rejection or in the office action. That's improper. But again, I'm holding us to a different standard. I'm holding patent practitioners to a bit of a different standard. So you shouldn't see Guidewire in the writing. Censure v. Guidewire. Again, thank you. It's helpful to identify the parties, but it's not proper. So again, here you can just drop the v. Guidewire and just list it as censure at 1176. So parallel citations. Now I want to talk about parallel citations for a brief minute because sometimes you have to. Because sometimes there aren't any other authorities, or sometimes you want to be more specific about where to find this particular authority. In general practice, and we'll see this later on, you do want to cite to the USPQ and the federal reporter, the appropriate federal reporter, but I'm going to touch on that subject a bit later. So what is a parallel citation? Parallel citation is a citing to two different reporters, two different authorities where a given opinion might be found. But if you're going to parallel cite, you should be consistent. Again, going back to some of our guiding principles for our citations, we want uniformity and clarity. So if you're going to parallel cite throughout your response. So if you introduce Alice with a parallel citation, if you introduce Mayo, if you introduce DDR or EnFish with a parallel citation, continue to parallel cite. Don't just do it once. It's not a one and done. It's you continue to parallel cite. Just some reminders that if you're going to cite to the Court of Appeals for the Federal Circuit, make sure that you, if you're going to parallel cite, you're going to want to use both the USPQ and the F3D. You'll find that a lot of the times if you download your opinions from Lexis or Westlaw or BNA, they list both where the reporters can be found. If you parallel cite to the Supreme Court, make sure you cite to both the USPQ and the Supreme Court reporter. And again, you can find some of that bibliographical information right from the opinion that you download. If you choose instead to get the opinion right from the Federal Circuit's website or from the Supreme Court's website, of course that information is not going to be there, and it's going to be incumbent upon you to go out and find that information the best you can. So just to give some examples of parallel citing, again, friendly Alice comes back to us. We see here, we cite both to the USPQ2D. We also cite to the Supreme Court reporter. In this first example, it includes the citation to the United States PQ, the Supreme Court, and then subsequent citations, including short form citations, should include both citations to the USPQ and the Supreme Court reporter. So don't just cite one of the reporters in your short form. You should have both. Now, I keep saying should. You're not going to get penalized for not having both. The examiner is not going to kick back your response and say, sorry, I can't evaluate your response, and I'm not going to read your arguments because they don't have merit, because you failed to parallel cite properly. But ultimately, as I said before, you're not writing for the examiner. Yes, the examiner is going to read your writings and evaluate your responses, but if this case, if your patent should ever get litigated, should ever get licensed, someone else is going to read your responses, and you want that other author, that third party audience, to read your responses and say, gosh, this person knows their material. Not only are they substantively accurate, they also know how to cite properly, and that tells me that this person has an intention to detail. Moving on to the next example. So here we have class of immunotherapies. Again, this is a case you might see cited to you quite frequently. I know I encounter it in my daily practice. So here, for parallel citations, again, similar rules apply to the case name. Use the first name of the first party. You can shorten the longer name. And again, as I've been mentioning through, you should be citing to both reporters in the short form. And we'll have some examples of how you do that properly. So here, this is what your short form is going to look like for Alice. So here you see a longer form to Alice, citing to both reporters. And then here you have 3 different examples of proper citations to Alice in its short form. So in the first form, in the first instance, we have Alice, the first party name, followed by the first reporter that we've parallel cited, which is the USPQ, and then the Supreme Court reporter, both pinpointing citing the 1978 page in the USPQ. And of course, the pagination is different in the Supreme Court reporter, so we cite to 2348. In the second instance, we cite to just the volume number. We don't cite to the case name. It might look odd for you to see that in of itself, but it is a proper short form citation. And then in the third instance, our friendly id makes a reappearance because it refers back to Alice Corp BCLS Bank. But if you notice that with the id, because the USPQ2D is the first reporter in our parallel citation, we do not have to repeat it when we use id. We can just say id at 1978. However, following that clause, you're going to have a comma and then cite to the second reporter as if it was any of the first 2 forms. So there's no, so with id, you drop the first reporter, the volume, and the reporter identification. Moving on, you have some improper forms of Alice. You can see it there. And then, here you don't just want to cite Alice. In each instance, you've basically lost a reporter, which is an improper parallel citation. So using id, it's a shorthand. We love to use it. We don't want to have to write out our cases every time. If a different page is being cited to, you're going to use the phrase at, which we saw in our previous examples. If you're using id for parallel citations, you want to include both sources. And as I mentioned earlier, don't forget to italicize or underline the word id, including the period. The Blue Book does make a very special point to identify that the period should be italicized or underlined. Now, if you notice here, and we'll get to it in maybe our next example, you'll see that id makes its appearance right at the end of our example. And here it refers immediately to our preceding example, the Bascom case. It's also citing right to the 1242. So because we are citing right to that pinpoint site without further explanation, and we're not parallel citing, we can just say id and be done. Now, I'm going to take a step back for 1 second and just identify something here that you might see. If you notice, I have parentheticals surrounding both my Bascom citation and my id citation. That is a stylistic choice that I have made. That is not a requirement. In fact, the Blue Book doesn't mention using parentheticals to identify your sources. But here you're going to want to end every clause that you cite with a period. So it should be Bascom full citation 2016 close paren period. That is called a citation sentence when it appears at the end of a prior sentence. So that's inline citation with a period. It's called a citation sentence. Same thing with the word id. You don't need a double period. I don't know if I had to bring that up, but you don't want to be doing a double period with your when you cite to id. Now here's one we don't see too frequently in my writing, but perhaps you do it, where you cite to an authority in the middle of a paragraphing. Here we have id as a separate clause. We call this our citation clause, and it refers immediately right back to Bascom at 1242. But if you notice here, we don't capitalize id. Id stays lowercase, and because it's a clause and not a sentence, we separate it out by commas because it's referring to the quote immediately preceding the word id, and then the quote following the word id is a different, appears on a different page at page 1244. And I've called it out here at the end of the presentation that you want to check your capitalization of the word id. Here you have parallel citations as an example. Hopefully in your own writing, if you need a little help, you can refer back to this example of how you properly cite using id and parallel citations. Now here, here we have id being used twice. Unfortunately, I couldn't find my own writing where I may have done this myself, so I pulled an example out of the Blue Book. Be careful if you have two authorities kind of having similar paginations, having similar references, you should not be using id. Now here, the reason why you shouldn't be using id is because both of these authorities have paginations that are pages 1 through 8, or appear in cite to the page 8, so you can't say see id at 9. It's confusing to the reader. So just watch when you're having multiple authorities that you don't need the word id when you cite to multiple authorities in the same paragraph. So just brief summary, introduce the case by its full form first. The short citation to only list the first party. When using parallel citations, be consistent and watch the use of id. So now inline footnotes and endnotes. Now this is a kind of a sticky topic because I know there are some people who prefer footnotes, there are some people who prefer inline, some people prefer endnotes. What's the quote unquote right way? So this hopefully will put this a little bit to rest, but at least according to the Blue Book, in non-academic legal documents, the citation should appear within the text. So there should be inline citations. Now I know a lot of you who footnote are saying, ah, geez, what do I do now? Do I have to throw out every response that I've written? No, of course not. You can continue footnoting, it's fine, but know that the expected form is an inline citation. Now that's not to say that you can't use footnoting, and there are in some cases footnoting is useful. So let's go through and talk about footnotes and endnotes and the differences. Endnotes, don't use. Just if you're endnoting your responses, if you're putting unless some local court requires you to endnote, don't endnote. And especially if you're dealing with a patent office, you should never be endnoting. Footnoting is fine, but inline citation is the preferred way of citing. So inline citations, some of the benefits, this is my experience, you can readily identify the source. I don't have to drift my eyes away from my reading. And so I can continue the flow of the argument. I know immediately what authority that person is citing. Footnoting, it does require the person to move their eyes to the bottom of the page to see what authority is being cited. So there is a bit of a disruption there. However, you can add more explanatory information to the end of your footnotes, which can be beneficial in some instances if you're trying to distinguish a case. But that's not to say that you can't omit footnotes completely if you're going to do inline citations. And in fact, I would suggest that maybe a mix of both might be helpful. Inline citations as appropriate, footnote where you need to add some explanatory or background information. Here I say be consistent, don't mix and match. And what do I mean by that? Well, Josh, you just said you can cite, you can do inline and footnoting. Yes, of course, you can do both. But my point is here is don't make your primary citations in both inline and footnote. Pick one for your primary citations. If you need to add background information, you can do that by way of footnotes. So here's an example of proper inline citations. You can see here, I get out the full cite from Mayo. I then give the full cite to Alice. I set it off by parentheticals. Now, parentheticals in parentheses and open parentheses and in closing parentheses, they're not mandatory, but they're helpful because they offset your citation to the reader. So examples of footnoting, we all know what a footnote looks like, so I just want to highlight to show you the differences of how they look. Here you can see that it's a lot clearer to read through the paragraph, but of course I kind of have to say, okay, well, what authority are they relying upon? So I have to drift down to the bottom of the page to see the footnotes. So again, it's a bit disruptive, but it can make for a more compact reading. So now, what's an example of both? I've actually seen this, and it floors me that someone would mix and match both citations and footnotes. This is just the paragraph I've written up from the last two examples. Don't do this. Pick one citation type and stick with it. Don't do both. So again, you should be doing inline citations in your responses and your appeal briefs. That is the preferred form for directly citing to an authority. Footnotes are acceptable, but use them sparingly and really use them for explanatory information or background information. Now, citing to a reporter. Which reporter do I cite to? Well, just kind of, you got a preview of that a bit earlier in the presentation. Supreme Court is SCT, Court of Federal Appeals is F3rd, District Courts is F-Sup, and that's fine. And you might be just citing those in your responses to office actions. You might be just picking one of those reporters and citing it. But there's actually something interesting. So you may say, well, what about the USPQ? Well, both the MPEP and the TMEP specifically mention the citation to the USPQ. They do say that citations should be made to the USPQ where appropriate and if possible. Here's a section from the EP. In citing court decisions, when it's convenient, you should cite to the federal reporter. And the alternative, the USPQ should be given. So it says an alternative, but we'll see how that differs from the TMEP. Citations which are not available to the public should be avoided. This means like internal agency publications or things that maybe you can only get via Westlaw or Lexis. And it's important to recognize that you can't cite something that's been overturned. That's more for the examiners. So here, this is the interesting distinguishing feature between the MPEP and the TMEP, is that the first line from TMEP says that when citing court or decisions, you should cite the USPQ, should be given right off the bat. And then if possible, so the flip from the MPEP, a parallel cite to the US, the federal reporters. So here you have both, here on the one hand, you have the MPEP saying, okay, you should cite, cite to the federal reporter, but an alternative cite to the USPQ. TMEP says, no, cite to the USPQ, and then cite to the federal reporter. So what that just suggests to me is that the preferred practice is at least cite to both. I know that may not be one you hear. You think, oh, geez, more work for me to cite, but this is kind of what we're left with, is that you have a little bit of distinguishing. You're left with the fact that the USPQ is important to the Patent Office, enough so that they would mention it at least in their examining procedure manuals. Typically I do see USPQ cited to me in office actions, both final and non-final. I do see federal reporters, examiners seem to kind of flip both. Some examiners cite to USPQ, some cite to federal reporter. In my mind, if you want to be safe, cite to both. If you have a question, I would cite to just the USPQ, simply because it's specifically called out by both the MPEP and the TMEP. And again, if you're downloading your opinions from Westlaw, Lexis, BNA, wherever you're getting it from, all three services list the source of the reporter right in the beginning of the opinion. So just when in doubt, parallel cites. It's always a kind of a belt and suspenders approach. So citing to agency material. So usually there are 4 general category materials that are authored by the Patent Office that you might see in your daily practice. You have communications from the examiner, decisions by the PTAB, memorandum, of course, with 101, we've seen lots of memorandum, and then notices in the Federal Register. And again, with a lot of the 101 movement, we've seen a lot of notices in the Federal Register, and even some not related to 101, but we're not going to touch on those today. So communications from the examiner, you might think it's intuitive. It is kind of, but I want to just give you some background information about why I'm putting this in here. Years ago, and from some of the older practitioners that may be on the line, the Patent Office used to assign paper numbers to office actions. And these paper numbers is what you cited to. And so there was no question of which document you were referring to when you said paper number 56, paper number 12. You knew you could look right away through the file history, the physical file history, mind you, and identify the paper number to which you were referring. So just everybody sees one of these office actions that are communicated today. Maybe you set it up with email. So here you see that the paper number is blank. They don't do paper numbers anymore. That has gone away with the electronic file wrapper. Now you have notification dates. So this is what we're going to do. And here I just wanted to highlight the fact that this response was non-final because that's going to be important for citing. So we're going to identify what the communication is. we're going to identify the date, and then we're going to identify the page number. So here, just an example, non-final office action dated August 11, 2017, page 4. And then once you've introduced this full office action, then you can then cite it by page number. So here I give you some examples of how to cite, and you can see that my short citation at the end, ID at 6, you can go right back up to that first parenthetical, see that it's the non-final office action dated May 24, 2017, and you know right away what I'm referring to. I'm bringing this up because I have seen some work product where the author simply writes non-final office action when they introduce it the first time, and this can be problematic because you may not know which office action you're referring to, especially when writing an appeal brief. If you're writing an appeal brief and you want to refer to an office action that the examiner wrote previously, don't just write in the non-final office action, in the final office action. Include the dates, be more specific. It's important. Submissions by the applicants. Here, you're going to want to focus on the amendment, the title of the document that's submitted, the day that you submitted it, and the page number. And I've given you some examples here of how to properly do that. And this becomes especially important if you want to draw the P-tab to an argument you made earlier. You're going to want to identify this document somehow. And so here you give it the full date of what you submitted previously. So decisions by the P-tab, you should have at least 4 components. You should have the case name, the document number, a secondary source, a reporter if possible, and the date. So one of the decisions that's presidential is the MIC Award decision that came out in 2015. So here I've cited, or 2017, here I've given you the full citation to it. At the top, you can get this from the Lexis database. I'm sure Westlaw has access as well. And this is the preferred way of citing to P-tab decisions, where you're going to list the full name, ex parte MIC award, the docket number, the database where you can find it, the court P-tab, and the date. And in the short form, you're going to include the paginations of the dockets, the docket number, and the star page of the Lexis database. So here it's at star 2. And so you're going to want to include that asterisk when you cite to it. Memorandum published by the USPTO. Now I've seen, there's been a lot of memorandum published by the USPTO, and I've seen all types of things. The May 2016 memorandum, the interim guidelines, the blah, 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 blah. Hopefully this will settle some of that discussion once and for all. First of all, you cite to the USPTO as the institutional author. It's not Robert Baer as the author, even though he technically has his name on it. He's not the author for citation purposes. It's the USPTO. You provide the title of the document or memorandum and the date. Those are the 3 components you need. I'm sure you've seen this, the memorandum that's available from the USPTO's website. And then here, you're going to say, so the full citation, it's a mouthful. You know, U.S. Patent and Trademark Office, comma, the title of the document, the memorandum. And then once you finish the title, open parentheses, and then the date, close parentheses. And then if you include this in a citation sentence, you're going to want to follow that with a period. So to be clear, the Blue Book doesn't expressly address internal agency memorandum, but they do talk about commenting. They do talk about other types of documents that the agency might issue. And by following this set of guidelines, you're going to conform with what the Blue Book expects. Now the question is, well, then how do I write to a short form citation? The Blue Book mentions that you should identify it using some unique identifier that can readily and accurately identify the document. So you might call it the May 2016 memorandum, you might call it the Baer memorandum, but whatever short form you choose, A, make it unique and so it's easily identifiable, and 2, be consistent so that your short forms consistently refer to that moniker of whatever you gave the agency memorandum. So notices from the USPTO and published in the Federal Register. So it's 3 parts: the commonly used name, the volume and page where the regulation might be found, and then the date. So when the 2014 interim guidelines on subject matter eligibility came out, this was the notice in the Federal Register. And I've seen that all over the place. I've seen multiple different citation people have cited to it differently. Once and for all, this is kind of how you want to cite to it. So it's 2014, interim guidance on patent subject matter eligibility, comma, volume, which is 79, Fed Reg 7416, 619, where it can be found, and then the date, December 16th, 2014. And then you see the short citation. So unfortunately, the short citation is really not much shorter than the longer citation. You're going to give the full name of the notice or the regulation, and then follow up by where you can find it in the register. Of course, when you use the id moniker, you can just say id at 74621, which will help you readily identify it. Moving forward. So just a summary. We'll go back 1 second. So just for citation purposes, I just want to highlight the author is an agency author. It's an institutional author, not the individual author. If the opinion if you're citing to an opinion authored by the PTAB, take 3 seconds, jump on Westlaw, jump on Lexis, jump on VNA, find out if it's cited in Reporter. If so, you'll be a superstar. Your citations will look awesome. Cite it. And then for citing to the Federal Register, I just gave you a quick breakdown. It's the name, volume number, Fed Reg, page number, date. Boom. So just you can use this kind of summary page as hopefully as a cheat sheet to your future citations. So now patents of public applications. We're just going to go through this briefly. The preferred way of doing it by the Blue Book is just to give the last 3 names. Yes, everyone will get a copy of the PowerPoint at the, if your name is on a distribution list, everyone will get a copy of the PowerPoint presentation. So I just want to jump through this real quick because I do want to talk about slip opinions before we run out of time today. So we're going to just jump here. So here, practice, when you have a patent, most people do this. I don't really see this as a problem. We cite to the last name of the first name inventor. So here it's U.S. patent number 2 Emmett et al. You just reference it as Emmett. Usually I don't see that as an issue. Here, just make sure when you cite to a patent that you include the column and line numbers. A lot of times I see citations that don't include these things. Don't forget your columns and line numbers. Just don't cite the patent. Just don't cite to the patent. Make sure you cite to both the column and line numbers. For application publications, it's the same way. You're going to want to cite to that last name of the first named inventor. So here it's Savjani. And then here, don't forget your paragraph number. Savjani at paragraph 5. So again, conformity, uniformity, whatever you're going to decide on for citing to patents and published applications, they should be the same. You shouldn't be citing your patents differently than you're citing your application publications. If you're going to choose the 3-digit way, use the 3-digit way, which is the last 3 digits of the patent or application publication. If you're going to use last name, then use the last name. Now just quickly, we're going to go look at what happens. So here we have a patent and an application publication cited by with the first named author. And of course, I get this constantly, especially when there's a patent family involved and the examiner's making a double patenting rejection and he wants to cite a whole family to you. Well then, what do you do here? How do you deal with these 2 documents? Usually you can do it as 1 or 2. So for example, I'll go back real quick. So here you can either use the last 3 digits or a 1 and 2 designation. And I'll show you what that looks like in practice. In practice, here you have the 040 patent and the 134 application publication. So that distinguishes our 2 documents. Now to me, this is the preferred way, and I'll show you why in just a second. When we get to the second example, where we have Andrews 1 and Andrews 2, this can get problematic because as you're writing, you are going to confuse yourself. It is just going to happen. Ultimately, you're going to say Andrews 2 says X, and you're going to cite to a column and line number, and you're going to say Andrew 1 says Y, and you're going to cite to a paragraph number, and then you're going to realize at the end of your writing, you've got them flipped, and now you need to go back and revise your writing to make sure you cite to the right document. You can easily address this problem by just citing to the last 3 digits of the document and be done with it. So you can use the 1 and 2 system. I don't think it's all that helpful. I think it lends to more confusion. But don't do this. So this is an example of what not to do. Don't mix and match. If you're going to pick a system, stick with the system. Use the 1 and 2. Use the last 3 digits. But don't cite like Andrews 1 and then the 135 publication, because all that does is just confuse the reader. It's like, okay, you cited Andrews 1, but now where's Andrews 2? Just don't do this. Pick one system and stick with it. Again, It's uniformity and conformity is going to save the day here. So again, I just want to kind of go through here. I do want to talk about block quoting just for a minute before we get to a discussion on slip opinions. Brian, how are we doing for time?
We're doing good. We're heading up on an hour here, so maybe
Okay.
within the next 10 minutes or so, wrap it up.
Perfect. Great. I might skip over signals. If we can talk, if you have a question about signaling, we can talk about signaling. But the two next topics I really want to hit on are block quoting and citing to slip opinions. So the question is, when do I block quote? When is it appropriate to block quote? Because a lot of times I see people take a sentence and they block quote it. Or conversely, they'll have a paragraph and it's just one long mess and I can't make heads or tails of it. So the magic number is 50. If the quote you're using is more than 50 words long, you should block quote it. If it's less than 50, you should put it in a line sentence. Well, what if it's 48 words? What if it's 45 words? I would say still block quote it. I leave it up to you. All of you are intelligent, capable people. If you look at a citation and you see, geez, I cannot see through this, then block quote it. On the other hand, if you think that it looks fine and you can read it and you can read the paragraph without being distracted, leave it as is. So a couple of notes about block quoting. When you block quote, left and right, you've got to indent the quote. So it's not going to have the same indentation as all your other paragraphs. No quotation marks. A lot of the times I'll see someone cite to, paragraph 6 of an application publication, and then they put quote marks around the whole quote. You don't need quote marks. Drop those. They have no bearing on the discussion. Get rid of them. Any quotation marks that do appear in the block quotes should appear as if they do in the original. So sometimes if the reference defines a term, like what it means to be a system or machine readable medium, you'll see quotes around it. Leave the quotes in there. Don't convert double quotes to single quotes. You don't need to do any of that. Just leave the quotes alone. They're not hurting anybody. They're fine. You don't need to mess with them. So just a couple of there's some longer rules here about block quoting. To me, the most important rules about these are the two, the first and the last. If the first word in that block quote is the start of the paragraph you're quoting from, and I'll show you what I mean by that, that word should be indented extra. You're going to be given an extra push. Otherwise, if it's a block quote that's appearing from the middle of the paragraph, you're going to leave the block quote with just the extra indentation that I mentioned earlier. At the end, you're going to cite to it, and that citation is going to appear, hopefully if you're doing inline citing, it's going to appear as part of your regular response or your document, and it's going to appear following the block quote. If you're footnoting, that footnote appears at the period at the end of the block quote. And I'll show you some examples. So here's the source material. I'm pulling it from the application publication we saw earlier. We have two different quotes, the yellow and the green, and I'll show you how we deal with each. So for the yellow, I've called it out here. This is how you should cite to block quote that yellow portion. Notice I've indented that. One shows that extra indent. So already my left and right, my 2 and 3 shows the extra indenting of the block quote. The 1 gives that extra push. And then at the 4, I cite to my authority or my reference. And here's Andrew's at paragraph 0021. The paragraph symbol is optional. I do suggest putting the brackets around the 0021. This way it doesn't confuse the reader as to whether you mean a page or a paragraph number. So let's look at the red side, or the green side, excuse me. That's taking a portion of a paragraph. We're citing from the middle of it. We're quoting from the middle of it. Here, we don't give it that extra push. Look at 1. So 2 and 3, we've already pushed our block quotes in. They're indented. But 1 is not indented. There's no extra push here because that thus, the word thus, is not the start of paragraph 25. It comes in the middle. So we leave it alone. And then again, number 4 shows that we cite right in line with the rest of our writing. And then we move on. We keep writing. So at the period, close parentheses, applicant respectfully disagrees. You don't need to put the citation at the end of the paragraph. It doesn't. Your citation does not appear in the block quote. It comes after it. The exception is footnoting. If you were to footnote, that footnote would come after the period in discussion. So it would be discussion period footnote. The footnote would not go after the block quote. Hopefully that's not too terribly confusing, but if you have any questions, I refer you to these slide examples, and hopefully these will get you through the day in block quoting. So signaling, I'm just going to talk briefly. Some of you might use signals. Just be careful how you use signaling. Most of the time we should be quoting directly from a reference or from an authority. If you're not, you're using your signals, your C's, your EG's, your C als's, your C generalese. Use them sparingly and use them intelligently. If you're using them all the time, that can detract from the authority of your writing. So just be careful with your signaling. I'm not going to spend too much time on here because we are running out of time, and I do want to talk about slip opinions. So slip opinions. More often than not with 101, kind of the Federal Circuit making these rapid fire decisions, we get slip opinions almost, it seems like almost on a monthly basis. And so what is a slip opinion? You should already know. If you don't, a slip opinion is an opinion that's available but not published. So if you go to the cfsc.gov, you go to their website, or you go to the Supreme Court's website, you can use a slip opinion right from there. When you cite to a slip opinion, you should cite the party name, docket number, court, and the full date of the most recent disposition of the case. More often than not, it's going to be the date on, that the opinion was decided. So here's the slip opinion from Alice. You know it's a slip opinion because right in the top left corner it says slip opinion. Look at that. And then here's the full cite. It's you use the full citation as it appears on the slip opinion. That's kind of key because again, the reporters might condense it, leave it up to the reporters, but for now you cite to the slip opinion, the party names as it appears on the slip opinion. I give it the full docket number with the date of the disposition. If you need to do pinpoint, you use the word slip op at 4. So if you're citing to another slip opinion that the Federal Circuit puts out later on, you say slip op at page number, and then you can see your source citation at the bottom, where it's a first party name, number, slip op at 4. Moving on. So selected for reporting but not yet reported. So in some instances, your slip op is going to enter this weird limbo phase where it's available. It's designated for reporting but not yet reported. So you're just going to leave a blank, as you see there in the bottom, showing you that, telling the reader that, hey, there is reported, so it's going to be publishing this opinion. I don't know where yet, so I'm going to leave a blank there. And that's perfectly acceptable way of citing. Then once it's cited, you're just going to want to give it to the full. Now here. So here, once the reporter has published your opinion, you don't cite to the slip opinion anymore. That's done. One and done. No more. Don't cite to your slip opinions. So if you're, check your writings today. You know, check them today. What was today? The 7th? Yeah, November 7th. So if you're filing a response tomorrow, double check your citations. Look at your slip opinions. Make sure that your citations, you know, any slip opinions to Alice, Mayo, DDR, Enfish, Bascom, Micro. No, there should be no citations to slip opinions anymore. That's really important that you don't do that. There is an exception, and so one exception would be where the let me just go back. Sorry about that. Where the opinion is published in an electronic reporter. Now, what do I mean by that? Or electronic database? What do I mean by that? If the slip opinion is only available from like Westlaw or Lexis or BNA, you're going to want to cite to those databases in addition to your slip opinion. That is the preferred way of citing it. So if you're still citing to slip opinions for whatever reason, and they've made their way into Lexis or Westlaw, Lexis, Westlaw, or BNA, make sure you cite to those electronic databases. I've given you example here, example 3. Don't forget your star paging. Yes, you include the asterisk with the page number. Star 7 is your example here. So here's an example of a response I reviewed recently. Here I saw citing to slip opinions of Enfish and Mayo and Alice. This is no longer appropriate. If you're still citing the slip opinion, you should be done with them. So again, once that slip opinion has made its way into a federal reporter or the USPQ, you should be done citing to your slip opinions. So just a summary of kind of what I've been saying about citations to reporters and slip opinions. Just just keep in mind that if it's only cite to slip opinions, that like first month when that slip opinion comes out, usually more often than not, a slip opinion makes its way into a Federal Reporter within 4 to 6 weeks. So just double check before you submit your response. If you're writing a response and it's in that limbo period. And that's it. That's my presentation for today on citations. Hopefully, you'll be able to go back, you'll review, and if you have a question about, well, how do I cite to this? How do I parallel cite to that? How do I block quotes? What are my signals? How do I cite to agency memorandum? You'll be able to go back to any of these examples in these slides and say, this is how I do it. And again, if you don't already have it, your #1 primary source for all this should be the Blue Book. If you don't already have it, pick it up. It's $40. I don't get any kind of compensation from them, but it is a resource worth having. And that is my talk.
Hey, thanks, Josh. So this is the new series. This is the first webinar that we've had in this series, having more robust presentations as far as doing hour-longs instead of half-hour-longs. The next one we're going to do is on the Patent Examiner Count System, and that one's going to be on January 24th. So thank you, everyone, for joining us today, and we'll see you soon. Cheers.